and we just came back on the record, is Alexia Law Firm, which is present here,
That's you, Lauren, right?
able to connect
Thank
into
you.
the Zoom hearing. Turn on your camera and your mic.
How's that?
Great. Well, I can hear you now. That's wonderful.
Okay.
Pause right there. This setup is already screaming trouble. We've got a cranky attorney, a contempt motion, and a dramatic walk-off teased in the first 20 seconds. That's not just courtroom tension, that's a full-blown legal showdown brewing. The real question is, who's about to lose control first, the parties, or the process?
I'm so sorry. I just have the worst cold, Your Honor, and may it please the court. I respect you immensely. So,
Oh, sure. So we were wondering, we've had a little bit of a hearing going on here, and we didn't know whether you were representing Mr. Meeks at this point.
only Mr. Meeks. I represent no entities whatsoever. Only
Okay.
Curtis Meeks.
Okay. So, thank you for making your appearance.
I'm so sorry, Your Honor.
It's fine. Mr. Watts will be excused. The order will stand that if Mr. Meeks does not get a lawyer to represent his LLC, that his answer will be stricken. So please prepare an order. Who would prepare that? Mr. Coomer, please.
Yes, Your
Prepare
Honor.
an order reflecting that decision. And hopefully,
Catch what just happened. This is subtle, but huge. The judge is drawing a hard legal boundary. An LLC cannot represent itself through a non-attorney. That's black-letter law. So when she says the answer will be stricken, what she really means is, game over by default. No defense, no argument, just a straight path to losing the case. And yet, somehow, this is only the beginning of the chaos.
it can be impressed upon Mr. Meeks, because I did a file review on the.
Okay, just a quick interjection here. I haven't seen this, but the fun's already started. She said I'm appearing only for him, which is appropriate. That's the scope of her representation. And the judge is already very nicely, but just like, well, let's knock that stuff off right now because this involves an LLC. So unless he gets an attorney in here to represent the LLC, then his answer is going to be stricken. In short, he's going to lose. I knew this one was going to be bad. I know it was so bad that I had to bust out the Justin Richard Clevenger, oh man, I gotta get it together mug from Covert Design. And yep, I had to put a cocktail in it.
break, that there's been a lot of opportunity for Mr. Meeks to please get a lawyer for your LLC, or it's going to be very bad news. There's just not much else that anybody can do. And it's a very important thing. And I think maybe, well, that's the ruling of the court on the motion to withdraw. It is granted. Mr. Comer is going to draft the order. Your excuse, Mr. Watts.
Thank you very much, Your Honor.
Thank you. Mr. Coomer, you may proceed on your motion.
Okay, thank you, Your Honor. Would you
And
prefer,
just for the record, and for people watching, this is against the individuals, Ricky Henderson pro se, and Mr. Meeks, who's represented by Miss Mia Alexa, I believe. Right.
Alexia.
All right,
Your Honor.
Mia Alexa.
It's Alexia Law Firm.
Okay.
And so we
Oh,
only represent Mr. Meeks individually,
Right.
no other entities.
All right. Miss
Thank
Alexia, did you have time to, now that you've made an appearance on behalf of Mr. Meeks in his individual capacity, have you had a chance to review the motion for contempt?
I have. Would you like a response, Your Honor?
Now we're stepping into the heart of the dispute, and listen carefully, because this is where legal strategy meets storytelling. A temporary restraining order, or TRO, isn't a suggestion, It's an immediate, enforceable command. Violating it within 2 hours? That's not a gray area, that's practically daring the court to respond. So ask yourself, is this incompetence or calculated risk?
Okay, well, let's go with Mr. Coomer's opening. He's given, you may proceed. Mr. Coomer, on your motion for contempt.
Okay, thank you, Your Honor. Mr. Bueller, will you put up our PowerPoint presentation, please? Okay. Thank you, Your Honor. Basically, this started on December 30th, 2022. A TRO was granted enjoining Curtis Meeks and his agents from selling or transferring the property, the Denfield property, that is the subject of this litigation. This TRO was granted on December 30, 2022. Since that date, the TRO was extended, and then a temporary injunction was granted and is currently in place. On January 3rd, 2023, less than 2 hours after Mr. Meeks and his agent, Mr. Henderson, were personally served with the TROs, they violated the temporary restraining order. Since January 3rd, 2023, both Mr. Meeks and his agent, Ricky Henderson, have been given numerous opportunities to purge or cure their TRO violations, but refused to do so. All they need to do is sign a special warranty deed that transfers the property back to AACSI Investments, where it should be. On December 30th, 2022, the court issued a TRO against Curtis Meeks and Ricky Henderson. Mr. Meeks and his agent were enjoined from enforcing an illegal and fraudulent deed of trust, as well as performing any of the following acts. The exhibit is D9, and basically you can see they prohibited from transferring, conveying, assigning, deeding, or otherwise disposing of or damaging the property. We know they were served by the constable at 9:50 a.m.
I mean, this could be done with judge. They transferred the property after they were enjoined from doing so. Next.
On January 3rd, 2023, they were personally served with the writs of TRO. They are the exhibits A and B to the motion for contempt. Both were served at the courthouse while attempting to have the constable foreclose on the property at the auction. I'll go over that exhibit when I take Mr. Meeks's testimony. Mr. Meeks originally filed a response to my application for a TRO, so he clearly knew the TRO was coming. Curtis Meeks and Ricky Henderson also attended a temporary hearing on January 12th, 2023, where they were shown the TRO. I explained to them with a PowerPoint presentation how they violated the TRO, and the judge at the hearing clearly instructed them to attend this hearing today. She issued a show cause order and recommended very strongly that they both hire counsel for this case. So I'm kind of surprised how long this has taken, because this is over a month ago, but they clearly had notice of the TROs. They violated the TRO less than 2 hours after it was served on them. There's 4 different violations of the TROs. I'm going to go over them.
Well, they waited
Basically,
2 hours.
on January 3rd, 2023, again,
Which is nice.
Approximately 2 hours after they were personally served with the TRO, Curtis Meeks directed his agent, Ricky Henderson, to administer the deed of trust. Basically, they enforced an invalid fraudulent deed on the property. This is a violation of Section 2A of the TRO. This is violation 1. And if you look at the trustee's deed, D8, you can see that there is a clear violation as in the deed records themselves and the trustee's deed. Let's go forward to number 2. We had them served through on the temporary injunction, on the show cause, on the TRO, through the constable's office. And in serving the TRO, the Travis County Constable tasked with conducting the public auction foreclosure sales was notified of the TRO and said, hey, we can't go forward with the constable auction foreclosure sale. However, once they figured this out and they were served with the TRO, Mr. Meeks and his agent, Ricky Henderson, drafted this trustee's deed, giving the false impression to the public that the sale.
This is where things start stacking up, and not in a good way. Multiple alleged violations, all tied to documented transactions, all backed by records. In legal terms, this is called building a paper trail, and once the trail exists, it's incredibly hard to walk it back. The deeper issue here isn't just whether rules were broken, it's whether this was done knowingly. Because intent? That's where consequences escalate fast.
Was conducted at the legitimate public auction. They actually even put the sale location in the deed to make it look like the constable's foreclosure sale, but it was not. If we can move forward. This sale was not conducted by any court, therefore it was a non-judicial sale of the property. Conducting a non-judicial sale of the property violates Section 2B of the TRO. That's the second violation of the TRO. Okay. The third violation of the TRO is the fraudulent deed purportedly sold, transferred, conveyed, assigned, deeded, and disposed of the property by seizing it, levying it, selling it. They also violated Section 2C of the TRO. This is the third violation of the TRO. All three of these violations can be seen in the trustee's deed, which is public record, and I will take Mr. Henderson and Mr. Meeks's testimony in a few minutes and we can prove that up. But violations 1 through 3 of the TRO can clearly be seen from a review of the TRO and the January 3rd, 2023 trustees.
It goes sideways.
Also of note,
Takes a little while.
This is the second time Mr. Meeks has attempted to transfer this same Denfield property from AACSI to Top and Ball Properties LLC. He did it the first time through a deed of trust back on February 2nd, 22, without any consideration. And
Objection to hearsay.
Well, this is his overview. You're going to get your opening statement too. So, or you can do your opening statement at the start of your case in chief. I mean, your case in chief. Your
Correct,
response.
Your Honor. You're correct.
Okay.
Thank you.
Okay, that right there is already weird. You don't affirm the judge. You're correct, as if you're in a position. You're not the judge's professor. The judge knows she's correct.
Basically, if you look at either the deed of the quitclaim deed or the trustee's deed, you'll see that both of them were transferred without any consideration, thus making them fraudulent transfers. Additionally, Mr. Meeks appears to have violated the TRO a fourth time. On January 11, 2023, Curtis Meeks sent an email to me that included an attached loan agreement that purports to encumber the property. This loan agreement, which appears to have been created in 2023, violates Section 2C of the TRO, and it was committed on January 11, 2023. We have D19, which we'll go over, which is the loan agreement. It purports to have been signed on October 30th, 2020.
Okay, this moment right here. This is where courtroom decorum starts to crack. There's a rhythm to legal proceedings: objection, response, ruling. But jumping out of sequence, interrupting, trying to control the flow? Judges notice that immediately. And when credibility starts slipping, it doesn't just hurt your argument, it reshapes how everything you say is perceived from this point forward.
But in looking at it, you'll see that there is a copyright date in the document of 2023 making it impossible for this document to have existed back on October 30th, 2020, and impossible for anyone to have signed it then. The document has several other issues, including it doesn't have page numbers, the fonts don't match. Also of note, I'm aware of Mr. Meeks having litigation, including criminal and civil cases, where there were allegations that he created false documents or forged documents.
I would object to that as character evidence, but moving forward.
Okay.
Oh my God, I didn't see this before. She is nuts. She's not in charge with that little intonation. First of all, he's giving an opening statement. Your objection's completely out of bounds. And then this pretending you're in charge of something. You're not. To the extent you could possibly make an objection, go ahead and say objection and then wait for a ruling. But you're not directing when we move forward or not.
If we can go back one slide, Mr. Bueller. We can go over Exhibit M in our supplemental motion for contempt. If
that was something.
The court wants to see it in our supplemental motion, Exhibit M goes over why we believe this loan agreement is fraudulent. If we can move on to the next slide.
Might be.
Additionally, we've given Mr. Meeks and Mr. Henderson multiple opportunities to cure and purge the TRO.
Also, Your Honor, so counsel respectfully, he is characterizing my client as being involved with the other person. So that is not accurate.
Because he is.
But let's move forward.
I'm just trying to give the court an opening.
Overruled. Go ahead.
Oh no!
I don't represent Ricky or whatever his name is, Ricky Henderson. So let's just focus on Curtis Meeks and and let's move forward.
Oh, she is so out of line. She might be altered. She might be drinking. I don't know. I'm not. But that is so out of line. Already. Okay. My motion for contempt is against both gentlemen. And
but that's not
okay. Ms.
And the judge gets it. She's smart.
She did.
She gets it.
Mr.
All right,
Miller,
let's stop interrupting. This is what he intends the evidence to show. If he doesn't show that, then you can hit him on argument.
Thank you. Since January 3rd, 2023, Curtis Meeks and Ricky Henderson have been given numerous opportunities to cure or purge their TRO violations, but they have intentionally refused to abide by the court's order. On January 6, 2023, after I found out that they had violated the TRO, I sent an email message to attorney for Top and Ball, providing notice of the TRO violation and providing Top and Ball and its sole member, Curtis Meeks, the opportunity to transfer the property back. This email message was ignored.
By whom?
It was ignored by attorney for Top and Ball, and his client was, Top and Ball's sole member, manager, and owner is Curtis Meeks. If we can move forward. On January 11th, 2023, after a motion for contempt and motion for show cause was filed by Movements, another email message was sent to the attorney for Top and Ball, providing Top and Ball and its sole member, Curtis Meeks, another opportunity to transfer the property back. This email message was also ignored.
You're presenting this as the opening statement, right?
Yes,
Okay.
I am.
Ma'am, I'm sorry. Please stop interrupting.
Seriously.
You may proceed, but okay, come on, wrap it up. So we have 4.
I will.
Government, fraudulent deed.
From what I've seen from this attorney, I think he's pretty good, but I hate the use of a PowerPoint here. Just say it. These guys are doing a bunch of fraudulent things, but specifically they conveyed a property fraudulently, made up a deed. There's a TRO against them transferring the property.
And here's the turning point nobody can ignore: mockery. When someone responds to legal demands with laughing emojis, it might feel dismissive, but in court, it reads as defiance. Judges take compliance seriously, especially with court orders. So now the question shifts from, did they violate the order, to, are they refusing to respect the authority of the court altogether? And trust me, that's a much more dangerous place to be.
Next.
Deed of trust, and then the non-judicial sale. So what else do you have?
Okay, I have that on January 12th, 2023, we had a hearing. Both Mr. Henderson and Mr. Meeks were there. I explained to them how they violated the TRO. I asked them to sign the special warranty deed to transfer the property back. They refused. We had to have a show cause issued, and we're having to have this hearing yet again, where we're Groundhog Day, where I'm saying, hey, transfer the property back through a special warranty deed. You clearly violated the TRO. It's been explained to them. Okay? If you can go back one more time, Willie. On January 20th, 2023, I sent another request, this time to Curtis Meeks' email address and to the Top and Ball attorney, giving him yet another opportunity after the January 12th hearing to transfer the property back. This is Exhibit D16. He knew he had opportunities. I got a response from Curtis Meeks and Ricky Henderson, and basically the response I got from Curtis Meeks used several laughing emojis and just kind of ignored my request. I get the idea he's laughing at us, and then he basically is making false accusations in his response, so it's clear.
State your name for the record, ma'am.
My email requesting the property be transferred back, and it's clear that they're refusing to cure their violations of the TRO. We can move forward. Since January 3rd, both Mr. Meeks and Henderson have had clear notice of their TRO violations. They've also refused to cure or purge their violations. I don't think either one of them will voluntarily cure or purge their violations without a court order. And just as a side, it's clear from doing research on both of these gentlemen, they both understand TROs and court orders. They've sought them in the past. So this is them just thumbing their notes at a court order. They both violated these orders. They both were clearly served with the TRO, had clear notice of their violations. They've had several opportunities to cure their violations, but refused to do so. And basically these not complying with these orders, it's not a mistake. This is intentional.
Okay. All right. You're getting into you've made your outline.
Okay. And just one more. What we're requesting is Curtis Meeks, as sole member of Top and Ball, signs the special warranty deed, Exhibit E, within 24 hours of this hearing. And then if he doesn't do that and file it in the public records, then he is fined $1,000 a day until he does that. We're also going to seek attorney's fees for having to chase this property for these violations and motion for contempt, but I'm fine with having the attorney's fee section of this at another date.
So you're reserving?
I am reserving, Your Honor.
And here's the turning point nobody can ignore: mockery. When someone responds to legal demands with laughing emojis, it might feel dismissive, but in court, it reads as defiance. Judges take compliance seriously, especially with court orders. So now the question shifts from, did they violate the order, to, are they refusing to respect the authority of the court altogether? And trust me, that's a much more dangerous place to be.